Good afternoon. In finance subtime, it's now 1:50, but we would like to call the finance, I'm sorry, I uh, put a disclaimer on that. I was throwing shade on finance sub, and it's actually finance full that has a problem with telling time at this point. But I do welcome you and would like to call the Finance Ways and Means Committee of the first extraordinary session to order again for August 24th, 2023. Do we have any personal orders or announcements? Seeing none. We do have a total of 13 bills on the calendar today. Item number 1 on the calendar is House Bill 7070.
Motion on the bill. Second.
We have a motion and a second.
I think we've got an amendment for this bill. It's amendment number 9640. We've got a motion and a second on the amendment. Chair Lady Hazelwood, you're recognized on the amendment.
Thank you, Mr. Chairman. This amendment includes a number of appropriations that will fund the initiatives that the House is taking into consideration. The first item that I'll go over, there's a permanently tax-free gun safety devices. We have had this on a non-recurring basis for several years now, but we are going to make this item into recurring for this budget, the remainder of this year, and for future budgets. That reduces the revenue by $1.6 million that the state will be collecting. So this appropriation amendment recognizes that. It also provides for $1.1 million of non-recurring funding that will go to the Department of Safety so that they can create, implement a public safety campaign that will encourage and hopefully educate Tennesseans about the proper way to store their guns. Also included in this amendment is school safety grants. We will be providing $10 million non-recurring for additional school safety grants. If you will remember, in this year's budget, we funded those, but these additional grants are for public charter schools and for schools that are within LEAs that do not have a full-time SRO for the 23-24 school year. These grants will be administered by the Department of Education, and these dollars are simply to fulfill the commitment that we made as a legislative body to provide an SRO for every public school and charter school in the state. We have also $30 million in non-recurring funds that will be allocated to higher ed for safety grants for those institutions. That's all levels of higher ed, including community colleges, TCATs, as well as our four-year institutions and our private colleges within the state. This is a departure. We didn't have higher ed safety grant funding in previous budgets, but we recognize that those campuses are vulnerable as well. This will allow those campuses to apply for these grants in these areas to either harden their securities. I just want to go on record again, as I did in Finance Sub, to encourage those institutions. These are one-time grants. They're non-recurring funding. So we would encourage the schools to use these monies in a one-time way. We have $12 million that is non-recurring in this budget for the recruitment and retention bonuses for behavioral health professionals that work for treatment agencies that contract with the Department of Mental Health. We all know there's been a lot of burnout. We have a shortage of these personnel. We need to make sure that we do everything that we can to both sign on new employees in these fields and to retain the ones that we have. So this $12 million will go towards that effort. We have the amount of the bonuses will be determined by the Department of Mental Health, will be based on the complexity of the positions that are in the bonus program. So, depending on education levels, and that's the amount of background and the amount of experience, they will be able to manage those grants according to those guidelines. Recruitment bonuses will require a minimum amount of service after payment of the bonus. So, and if you do not meet that minimum requirement of terms of service, then the recipient will be responsible for fully repaying that bonus amount. And the department will be required to report back to the Finance Committee by December of this year. That report will be required to include the number of recipients, the amounts, the locations, as well as just a general summary of the impact on the program services. So we know if these dollars really made a difference, the difference that we expect them to make. Included in this appropriation amendment as well is the scholarship program, $3 million non-recurring for public behavioral health scholarship program. These scholarships will provide tuition stipends to those that are pursuing a degree in the behavior health related field. Again, we recognize we have a shortage in this area of healthcare, as we do many others. Hopefully these scholarships will entice and incentivize Tennessee students to go into these areas, these professions. The scholarships recipients will be required to work for the Department of Mental Health Contracted Treatment Agency for an amount of time equivalent to the amount of time the recipient receives a scholarship stipend. So if you're a senior and you're getting the stipend for 1 year, then you have a 1-year obligation. If you're a junior, you're getting a 2-year stipend, you'll have a 2-year obligation, and so forth. The department, again, will be required to report back to the Finance Committee by December 31st of this year with details regarding the number of recipients, how the scholarships amounts were awarded, the types of degrees pursued, and again, give us an idea of the general impact of the program on the expansion of services or the expansion of those available to give those services. There's $4 million that non-recurring that will be appropriated to the behavioral health safety net. That safety net provides behavioral health care services to persons who are uninsured and are not eligible for TennCare. So in that gap, there will be $4 million to provide services for those individuals. There is a $50 million non-recurring amount that we will be pulling that from TennCare reversions, not from reserves, but from TennCare reversions. And that will fund a provider rate bonus for the mental health care providers who are, I think most of all, us have probably heard from mental health providers in our various districts telling us that they cannot afford to keep providing care at the rates that the state is paying. So this will address that issue. We also, in this appropriation grant, will be paying for the cost of this session. So with that, Mr. Chairman, I would take questions from the members.
Thank you, Chair Lady Hazelwood. Members, you've heard the explanation. Are there any questions on the amendment? Representative Miller.
Thank you, Mr. Chairman. My question is in reference to the $30 million. Are these new dollars?
Chair Lady Hazelwood.
The $30 million, I'm sorry, for the higher ed safety grants.
Yes, Madam Chair.
This is from the $50 million that we had left from closing. I'm sorry. I'm sorry, we have to have Ms. Hines keep me straight on which pot of money we're pulling this from. We had allocated some dollars in the budget for a new prison. That we're not doing that, so we are pulling that money from, that was $50 million allocated there. So we're pulling that funding from that pot.
Thank you. Next question in reference to the $30 million. These are grants and individual institutions can apply for these grants. Would that be based on first come, first serve? And would there be I guess a maximum amount each institution can apply for?
The department will be looking into the rules for the grant making process. I believe that our intention is for those grants to be, we would not want all of this $30 million to go to one institution. So we would certainly hope, again, that's why we've opened this up to higher ed institutions at all levels. So we recognize that whether you're at a TCAT, a community college, or for your institution in the state, that there are safety concerns, and we would want to make these available for all of those institutions. But again, there is a finite amount of money. One of the things that we'll be looking at is reporting back on how those grants were spent. That will also give us an idea. We'll be asking for what grants were not fulfilled, so we'll know what the unmet need is, and determined by the amount of dollars that we have available in next year's budget. That is certainly a data point that we'll be using to look at whether or not to expand, continue, or what we do with these on future basis. But this at this moment is non-recurring money.
Thank you. Thank you for that.
Okay, any other questions on the amendment? Okay, if not, then we are voting on putting Amendment 9640 on House Bill 7070. All in favor say aye. Opposed? Motion passes. We do have a second amendment. This is Amendment 9373 by Leader Lamberth. Leader Lamberth, you're recognized.
Thank you, Mr. Chairman.
Got a motion and a second.
Thank you. And this amendment actually comes from Representative Tim Rudd. In talking to some of our private schools, we set some money aside, about $14 million, if I remember correctly, during the budget process this year for hardened school security to try to help our private schools after the horrific shooting at the Covenant School. What we did not do is we did not backdate that to March 27th. And so after March 27th, there are many of our schools that immediately begun trying to find funds and found some funds to harden their schools, to make their children safer. And what this amendment would do is just within the funds that are already allocated, allow any private school that did spend funds after March 27th to make their schools safer to be able to access those funds.
Okay, thank you for that explanation. Are there any questions on this amendment? Okay, if not, then we're voting to add Amendment 9373 to House Bill 7070. All in favor say aye.
Aye.
Opposed? Motion passes. The amendment is added.
That brings us to item number 2 on our calendar, House Bill 7027. That's by Leader Lamberth. I apologize. We voted on amendment, but we did not vote on the bill.
Sorry about that.
Okay, members, we need to now discuss House Bill 7070 as amended. Are there any questions on the bill? Okay, question's been called. If you're ready to vote, then all in favor of passing House Bill 7070, all in favor say aye.
Aye.
Opposed? Motion passes. House Bill 7070 passes to calendar and rules.
And now we are on item number 2 on our calendar, House Bill 7027. Leader Lamberth, you're recognized.
Thank you, Madam Chairman. Motion. And this bill is very straightforward. It just undoes what I think was an injustice that occurred well before most of us were here, and it happened just because of budgetary reasons. The state stopped paying for mental health evaluations for indigent defendants that were charged with misdemeanors. They did pay for indigent mental health evaluations for accused felons, but not accused misdemeanors. This, for $2.5 million, we can help hundreds of people get help sooner and intervene before they do something horrible.
You've heard the sponsor's explanation. Do we have any questions? Seeing none, we're voting on House Bill 7027. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 7027 moves to calendar and rules. Item number 3 on our calendar today is House Bill 7006 by Chairman Sapicki. Chairman Sapicki, you're recognized. We have a motion and a second. Chairman Sapicki, you're recognized. Tell us about your bill, please.
Thank you, Madam Chairman. Very briefly, ladies and gentlemen, It allows the Department of Mental Health and Substance Abuse Services to direct available state funds to contract with additional private service providers across the state to provide inpatient psychiatric services for uninsured individuals in the state. And also, on or before December 31st of 2024, the department shall submit a report to the Speaker of the Senate and the Speaker of the House of Representatives on whether additional inpatient psychiatric services are needed in the city of Knoxville, Tennessee. And report must include the recommendations on whether additional state funds should be expended for the construction of a state-owned and operated inpatient psychiatric facility in the city of Knoxville. That's what it does, Madam Chairman.
Are there questions for the sponsor? Seeing none, we're voting on House Bill 7006. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. Chairman Sapicki, House Bill 7006 moves to calendar and rules.
Thank you, Madam Chairman.
Next on our agenda is House Bill 7023, also by Chairman Sapicki. Do I have a motion? I have a motion and a second. Chairman Sapicki, you're recognized.
Thank you, Madam Chairman. Members, if a local board of education has not entered into a memorandum of understanding with a law enforcement agency to assign a school resource officer at each school within the local board of education's control, then a law enforcement agency with jurisdiction may assign at least one law enforcement officer to serve as a school resource officer at the school to increase the protection and safety of students and school personnel during the regular school hours when children are present on the school's premises, as well as during school-sponsored events. That's what the bill does, Madam Chairman.
All right, you've heard the sponsor's explanation. Representative Shaw, I believe you had a question.
I do, Madam Chair. Thank you. And I was in the other committee, and I'll admit my attention was drawn someplace else when you presented that. Are these law enforcement officers that would respond, they're going to be trained law enforcement officers or just whoever they got on staff?
Chairman Sapicki.
Thank you. First of all, it would be at the discretion of the chief law enforcement officers, but it says in the bill, these are law enforcement officers. And, Madam Chairman, they don't respond, they will be placed in the school. So there'll be personnel in the school.
Oh, okay. But that would, whoever they are, that would be who they are, I guess is what you're saying. Okay. I don't know. I have a little bit of, I appreciate you bringing this, but I have a little bit of a problem with that. I heard that after you said it and it was a little late, but I need to think through that one personally, but thank you for listening to me.
Yes, sir.
Any additional, Representative Miller.
Thank you, Madam Chair. Lady, just one question. I'm reading the content of the bill, and it says the bill prohibits an LEA from impeding on the duties of the officers who is assigned to the school. Give me an example of how the LEA could impede this officer.
Chairman Sapicki.
So in the bill, it lays out that the director of schools and the principal of the school that a law enforcement officer is being assigned. It lays out the things that it lays out the officer's assignment, the policies, the procedures, a description of policies. And what it does is it does not allow the LEA to interfere with that law enforcement agent's job, such as the principal could say, I want you to patrol this bathroom and that's it during the day. That would be impeding the law enforcement agent's job to patrol the school to make sure it's safe. So that would be an impediment that a school could place on there, and it says they cannot impede what the law enforcement agent's job is during the school day. Okay.
Representative Miller.
So the officer will come into that setting with preconceived policies, directions of what that particular officer will do. They will make that determination of their duties and responsibilities, is my question.
Chairman Sapicki.
The officer would not, the head law enforcement officer who assigns them there would have that all detailed out for the school and the principal.
Okay, thank you.
Representative Freeman.
Thank you, Madam Chair. What areas do not currently have a memorandum of understanding? Do any LEAs right now?
Sorry.
Chairman Sapicki.
I'm assuming based off of what Chairman Love told me in the previous committee, I think there may only be one still.
Which,
Representative Freeman.
which one?
I'm not sure. They're working on it.
Representative Freeman.
So you don't know, and you're bringing a bill to change state law?
Chairman Sapiki.
Well, all this is doing is if a LEA, if a superintendent and head law enforcement cannot agree on a memorandum of understanding to place SROs in the schools, what this bill allows is that the chief law enforcement agent with jurisdiction, under the obligation of an oath of office to public safety, can place law enforcement officers in those schools. That's all the bill does.
Representative Freeman.
And does this require the same level of training of a existing SRO officer for the replacement officer that they're putting in?
Chairman Sapiki.
It would be a law enforcement officer that has gone through the academy, that has gone through all the training to be able to be a law enforcement agent.
Representative Freeman.
Sorry, last, this is going to be a comment. I guess I have an issue with us putting law enforcement officers that don't have the specific training to be within a school. And you can't tell me that this is an existing issue right now. I know earlier you believed that it was Nashville, and a memorandum of understanding was produced between MNPS and Nashville Police Department. And so this kind of seems like a solution looking for a problem, but if it is a problem, it's something that needs to be addressed, but I'm not so sure that it is. But anyway, thank you.
Chairman Sapiki.
Thank you for those comments. Currently, we have 147 MOUs that exist in our school system that at any time a superintendent could say, I don't want to do it anymore. This gives additional security to those schools and those law enforcement agents that they would have the ability to uphold their oath of office of providing public safety for those schools and those children.
Representative Parkinson.
Thank you, Madam Chair, lady. To the sponsor, the districts will have no say in this. I just want to walk through it. So if the districts don't have an MOU with law enforcement and law enforcement decides to put an officer in the school, the districts cannot say, hey, we don't want to do that to law enforcement. Can they?
Chairman.
If the
Chairman
district-
Sapiki.
Thank you. It's not the district, it's the superintendent has the sole discretion. If the superintendent of a district says they don't want to enter into an MOU to provide security and safety for our children, chief law enforcement now would have the ability, and it's May, they don't have to place them in the schools, but it gives local law enforcement over jurisdiction to give the ability to place them in a school to provide security for those children.
Representative Parkinson.
Thank you. I'm not sure if you answered my question, to be honest with you,
I did.
but so let me ask it again a different way. If the district doesn't have an MOU with local law enforcement, and they say, we are refusing to allow you to put your officer in the school, can they do that?
Chairman Sapiki.
The answer would be, if I understand your question right, could a superintendent say, I do not, under any circumstances, want to protect the children in our schools? They have that ability to do that. But this bill would allow them to come in behind law enforcement and say, no, we're going to protect the children.
Representative Parkinson.
Thank you, Madam Chair. Madam Chair, I would like my words to be my words and not the words of the member changing them to say something else. I did not say that a superintendent said, I don't want to protect our students. So I'd appreciate it if you'd be honest and keep it real.
President Parkinson.
Yes, ma'am. I do have a follow-up question, Madam Chair, lady. So let's say an officer or law enforcement forces an officer into a school, and an incident happens where their weapon is discharged and someone gets hurt. Where does the liability lie?
Chairman Sapiki.
Because there was no MOU signed, it would lie with law enforcement.
Representative Parkinson.
Thank you, ma'am. And this is my last one. So I just want to be clear. all of the liability for any incidents that take place if law enforcement places an officer in the school will lie with that law enforcement agency.
Chairman Sapiki.
That's correct. The thing that transfers the liability to the school system would be the MOU. Without the MOU, you could not transfer the liability.
A question to you, Madam Chair, to you. That's why I hurry up and said it. Is that in the bill? Can we ask legal if that's actually in the bill that the liability would lie with law enforcement?
Without objection, we'll go out of session. We'll get an opinion from legal. Without objection, we're out of session.
Joel Hayes, Office of Legal Services. Representative Parkinson, I'm looking at the bill and I do not see any mention regarding liability. I mean, again, it would fall under essentially what the current standard is for, facts and circumstances and a determination of whether or not, governmental tort liability and immunity, all that stuff is unchanged and would still be, factored in determining who is liable in this situation.
Thank you.
Mr. Hayes, am I given to understand that in this situation, the liability would be determined just as the same way it would if law enforcement discharged a weapon in any other location or any other situation?
Likely, yes. Again, it's something where this bill does not address liability one way or the other. It does not change how liability would be determined.
Thank you, Madam Chair Lady.
Any further questions for legal while we're out of session? Seeing none. We're back in session. Representative Barrett.
Thank you. Question for the sponsor. There seems to be some consternation about who does or does not have an MOU. Are MOUs indefinite?
Chairman Spicky.
From my understanding, between the superintendent and law enforcement, they can be revoked at any time.
Representative Barrett.
So for your bill, how would it kick in the instance where an MOU were to expire or to be terminated by a superintendent?
Chairman Spicky.
Upon notification of law enforcement that the MOU has been terminated, this bill would kick in to give law enforcement the ability to continue to enforce, making sure our children are safe in our schools.
Chairman Whitson.
Thank you, Madam Chairman, and thank you, Chairman, for bringing this. It's my understanding we routinely, or LEAs routinely employ or assign non-SROs for special events such as graduations, sporting events, and at schools, correct? And they are not SROs.
Chairman Spicky.
That would be correct.
Yeah, and this also could just be a temporary measure based on a threat or a shortfall of SRO resources, correct?
Correct.
Chairman Spicky.
Thank you. Correct.
Okay, thank you.
Leader Cochran.
Thank you, Madam Chairman. Chairman Spicky, your bill would only apply to public schools, correct? County schools, city schools. Those are the systems that this bill would affect.
Chairman Sabicki.
Where the MOU comes into effect, yes, sir.
Thank you. To your knowledge, in every county throughout the state, who is the chief law enforcement official in that county? What office is that?
Chairman Sapicki.
Well, it's jurisdiction with the schools. So in Metro Nashville, I believe it would be Metro Nashville Police Department. In Murray County, it would be the Murray County Sheriff's Department.
Thank you. That's correct. And so, in most counties without a metro system, it is the county sheriff's department. The hand-wringing of allowing the sheriff's department into a public school seems somewhat baffling to me. I believe that makes perfect sense since the sheriff is the elected, the chief elected law enforcement officer of that jurisdiction for both cities and counties. That is the one law enforcement officer that can enforce the law anywhere in the city, in the county, wherever they are. And we're talking about allowing them into public school systems. That seems to make sense to me. So thanks for codifying something that is common sense. I appreciate the bill.
Representative McKenzie, you're recognized.
Thank you, Madam Chair. just to make one comment, I think the consternation is in that type of training. I think SROs are sensitive to, K through 3. They've been trained in that K through, 6 or K through 5. I think the SROs are, they're we want to call them law enforcement. They're school resource officers that have, the power to carry a weapon, but they've been specially trained. So, and I think we talked about that some in education. Not all sheriff deputies are the same. If there's a SRO who's trained, a sheriff deputy who's trained as a SRO, like in my county, doing city police and county police, it makes sense. But just to have someone on SWAT or on violent crimes be assigned to a school, there's just a different type of training. And again, we talked about that yesterday. But my question to you, is a memorandum of understanding a legally binding document? And it may not, I may have to go to legal, but is that a legally binding document as we talked about liability and things?
Chairman Sapicki.
Madam Chairman, I would allow your attorneys to probably answer a memorandum of understanding legally.
Without objection, out of session. Mr. Hayes.
Joel Hayes, Office of Legal Services. Representative McKenzie, generally an MOU or memorandum of understanding is regarded as a contract between the parties. And so whatever clauses and stipulations that there were in that contract would be, binding.
Thank you.
Without objection, back in session, and Leader Lamberth.
Move previous question.
Previous question has been called. Seeing no objection, we are voting on House Bill 7023. All in favor, please signify by saying aye.
Aye.
Any opposed? If you'd like your no to be recorded, please see the clerk. House Bill 7023 does pass and moves on to calendar and rules. Thank you, Chairman.
Thank you,
Sapicki.
Chairman Committee.
Item number 5 is House Bill 7034 by Chairman Grills. We have a motion and a second. Chairman Grills, you're recognized.
Thank you, Madam Chair. I believe we have an amendment that's following the bill. Just want to make sure. 9502.
It is traveling with the bill.
Thank you.
You have a motion and a second. Please proceed.
Thank you. This bill does a few things with stalking, and it increases the penalties for stalking and aggravated stalking, and it also requires an independent professional mental health assessment of the defendant to determine their need for mental health treatment if the person is convicted of stalking, aggravated stalking, or especially aggravated stalking. This assessment indicates a need for mental health treatment, then the court shall include that as part of their sentence. And as a condition of bail or a pretrial release, the defendant may also be required to undergo an evaluation. With that, I stand for questions.
Heard the sponsor's explanation. Do we have any questions? Representative Miller.
Thank you, Madam Chair Lady. Representative, like the bill, like what the bill stands for, especially when part of it requires a court order for mental health assessments. Just curious about the cost and just what I'm looking at here. Increased state expenditures by $9,766,000, et cetera. Is that accurate number?
Chairman Grills.
Thank you, Madam Chair. I do not work with physical review. They are the ones who put that together. I'll let them answer that question. Do I know?
Madam Chair, right. I'm just curious about that because if we talk about $9 million, how do we even come up with that number? May I ask that question?
Without objection, we're out of session, and we will ask Ms. Karshner to give us an explanation on the fiscal note.
Krista Karsner, Fiscal Review Committee. Representative Miller, we have a process that we go through on incarceration notes that looks at trends in admissions into the correctional system, the cost per day, depending on which felony class that they will fall into. And then we do a 3-year trend, and it's the highest of the 3 years is what we have to fund.
Thank you for that explanation. It just seems as if I guess if you apply that amount to an individual, the question is, how many individuals are we even looking at possibly coming within this
Ms. Carson?
law?
Representative Miller, that is not per individual. That is per the total that would be admitted over the 3-year period.
Okay, thank you for that. Thank you, Madam Chair. Thank you.
Are there further questions on the fiscal note? Seeing none, we're back in session. And Chairman Grills, I do not see any further questions. Questions been called on the bill without objection. We're voting on House Bill 7034. All in favor, please signify by saying aye. Any opposed? The ayes have it, and House Bill 7034 moves to calendar and rules. Next on our calendar is House Bill 7063 by Chairman Rudd. Chairman Rudd, we have a motion and a second. You are recognized.
Thank you. This bill is it's a simple bill, and it's designed to meet a very, very important need. As you know, as SROs, especially in rural counties, we're finding it very hard to find law enforcement to hire to be trained to serve as SROs. And what this would do, it's totally permissive, but it would let the LEA open that up. If they could not find deputies to serve, they would open it up to retired law enforcement and veterans, and they would have to meet certain stringent requirements and plus any additional policies or requirements that the LEA were to put in place. Now, these individuals would not work for local law enforcement. Unlike active duty, they would work for the LEA, so they'd be open to be employed by them and report to them. And that's what the bill does.
Questions of the sponsor? Seeing none, we're voting on House Bill 7063. All in favor, please signify by saying aye. Aye. Any opposed? Ayes have it. House
Thank you.
Bill 7063 moves to calendar and rules. Item number 7 on our calendar is House Bill 7073 by Chairman Vaughn. Chairman Vaughn, we have a motion and a second. You are recognized.
Thank you, Madam Chairman. Easy for you to say.
And we do have an amendment on this bill. The drafting code I'm showing is 009589.
That is correct. And then I would also like to place another amendment on there as well, Chair Lady.
So we are voting on attaching drafting code 009589. All those in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. Drafting code 009589 is now part of House Bill 7073. We have another amendment that Chairman Vaughn is bringing forth today. That amendment number that I'm showing, Chairman, is 009643.
Yes, ma'am, that is correct.
We have a motion and a second. Would you like to explain this amendment to us?
Yes, ma'am. We used old terminology in amendment coded 9589. We referred to a general educational development certificate. The new language that the Department of Labor uses is obtain a high school equivalency credential approved by the State Board of Education. So we changed all references to GED to bring it into this high school equivalency credential. So we didn't want to bring a new bill in with improper terminology.
So we have a technical amendment on House Bill 7073. Any questions regarding that amendment? Seeing none, we're voting on attaching House Amendment number 009643. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. We now have the bill amended and in the proper order. Would you please like to explain that to us, Chairman Vaughn, the bill as amended?
Yes, ma'am. Thank you, Chair Lady. This is the Speaker's blended sentencing bill and transfer bill. It's got two major parts. The transfer part basically says that if you're convicted of attempted or if you're arrested or charged with attempted first or second degree murder and you're 16 years or older, then you'll be tried in adult criminal court. So 16, 17-year-old folks that have been probable cause for attempted or they completed the act of first or second degree murder, they'll be going to criminal court. With regards to the blended sentencing, the issue that we're trying to address here is the revolving door that many of us see, particularly in urban areas, of the juvenile justice system to where I know in Memphis, we've had some cases of juveniles with ankle monitors have been rearrested for committing crimes. And so that's one of the things that we're trying to enforce here is give juvenile court judges, a little more leeway, especially in these older youthful offenders, to be able to add more time based upon the severity of their crime. What I'd like to point out is that this only, the term that we're using here is a serious youthful offender. And it's a child 14 years or older. Now then, for a serious youthful offender for a 14-year-old or older is if it is first-degree murder, between 14 and 16, if it's first-degree murder or second-degree murder at the commission of the offense. But here's the other list of serious youthful offender charges and convictions that people would fall in under this. And it's rape, aggravated rape, rape of a child, aggravated rape of a child, aggravated robbery, especially aggravated robbery, especially aggravated burglary, aggravated kidnapping, especially aggravated kidnapping, carjacking, commission of an act of terrorism, aggravated child abuse or aggravated child neglect and endangerment, or a Class A or Class B felony offense involving the use of a deadly weapon during the commission of that offense. So what we're trying to do is, with these folks who are engaged in particularly violent criminal behavior, that we allow the juvenile court judges to consider the fact that they can see how they're going through their rehabilitation. And at the time of their adjudication, they can add this additional time on past their 19th birthday. But if the offenders are taking real strides towards rehabilitation, then they can have that time reduced through a hearing within 4 months of their 19th birthday. And what we had a lot of discussion about this in criminal sub and criminal full. And what we did was we said, okay, here's what will happen is you can consider whether or not the additional time after 19 has been, we're agreeing to shorten it. But here's what you've got to do in order to get that thing shortened. You can't commit another delinquent act, so you've got to keep your nose clean. You can't be engaging in conduct that creates substantial safety risk. So if you're in a juvenile detention facility, you can't be leading a riot. You've got to be making sure that you're following the rules, and then fail to meet the conditions of supervision during the determinate disposition prior to the hearing. So basically, if you're on probation, you've got to follow what your probation officer's doing. So if you do those things, or if you also attend school regularly with passing grades, graduate or get your what used to be called a GED, that also counts. Or if you get regular employment and you're productively employed. So out of all of these things, if basically we've got 6 conditions here, if you meet 3 of those or half 50% of them, then the judge can consider staying that time between 19 and 24. So it's a way that folks who are serious about rehabilitation can prove that. And then it also, for those who are not serious about it, then it gives the judge the opportunity, the juvenile court judge, the opportunity to keep them under supervision. So that's the bill. I'll be happy to answer any questions. We did, as mentioned in finance, we did make 3 substantial changes to the bill from the time it was originally offered for consideration. Number one is we put the floor of 14 years old on there so that no one would have to serve time for a crime that would be more than an adult would have to serve. So that was a situation we changed. We removed Class C felonies from something that will add additional time. And then we also went to 50% of the requirement list as opposed to 100% of the requirement list. So that's what we've done, and there is a fiscal note associated with it, and those items did significantly reduce the fiscal note on the bill.
Thank you, Mr. Sponsor. We do have some questions. Representative Freeman.
Thank you, Madam Chair. And sponsor, thank you for explaining your bill. Currently, how does someone get a blended sentence today? I mean, it's up to the discretion of the judge, or who decides that? or who decides how they're going to, if they're going to be charged as an adult today?
Chairman Vaughn.
I'm sorry, Chair Lady. It's a conference between the DA and the juvenile court judge where they look to see if they're going to, where they're going to send the offender.
Representative Freeman.
And you're bringing this because you don't think that our current judges and DAs are making the right decisions?
Chairman Vaughn.
I don't have all the facts that they have. I do know that what we've got, Representative, is a drastic increase in serious violent juvenile crimes in my particular area of the state. So whatever is working, we're trying to add another tool that a juvenile judge can use to deploy against these serious youthful offenders.
Representative Freeman.
Yep, sorry. I guess my issue is the requirement that it takes the discretion out of the hands of the judge and the DA to treat the situation as it's on the specific cases and on the specifics of the case. But I'm all for making sure that these people serve the time they deserve. But we've got a 16-year-old that's a minor. They don't have the mental capacity to understand the consequences in many cases of their actions, and we're going to require them to be charged as an adult. It seems like a tough deal, but anyway, thank you anyway.
Chairman Vaughn.
I have no reply.
Representative Love.
Thank you, Madam Chair and sponsor. This is maybe a technical question. When you make reference to acquiring the GED, is that going to be inclusive of the high set also, or is it only GED specific?
Chairman Vaughn.
I don't understand the question, Chairman Love.
Okay, so there's a GED, but there's also a high set test one can take to get your high school equivalency. So in the
Excuse me. The amendment cleared that up because now it refers to a high school equivalency credential that's approved by the State Board of Education.
All right, thank you. Thank you, Madam Chair.
Leader Lamberth.
Move previous question.
Previous question has been called. See no objection. So without objection, we are voting on House Bill 7073 as amended, moving to calendar and rules. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 7073 moves to calendar and rules. Thank you, Chairman Vaughn. Item number 8 on our calendar is House Bill 7012 by Chairman White. Chairman White, you're doing just-in-time delivery, and you're here with us. We have a motion and a second. Chairman White, you're recognized.
Thank you, Chairman. Committee, we're on safe storage, 7012.
Yes.
Okay, thank you. Committee, this is came out of the administration's work this summer on safe storage of firearms. It does 4 things. The state's going to provide free firearm locks for all Tennessee residents that request it. Item number 2, the Department of Safety and the Tennessee Bureau of Investigation will work together to create a public safety campaign dedicated to firearm storage. The third item on it is that all department-approved handgun safety courses shall include an instruction on safe storage of firearms. And lastly, it also exempts the sales tax on retail sale of firearm safes and firearm safety devices. And with that, Madam Chairman, renew the motion.
And Chairman White, we do have an amendment, I believe, on this bill.
Yes, what's the number you have?
009588.
Yes, I think that was in subcommittee. Added that.
So the bill that you described is as amended, is that correct?
Right. The amendment, from what I was given, is that it says that any previously approved storage instruction of firearms that was already on a file would be included in the new instructions on firearm safety.
All right, so for procedural purposes, we need to adopt the amendment, drafting code 009588. All those in favor, please signify by, we have a motion. We have a motion and a second. All those in favor, please signify by saying aye. Any opposed? The ayes have it. The amendment is adopted. You have heard the sponsor's explanation of the bill as amended. Are there questions of the sponsor? Seeing none, we're voting on House Bill. I'm sorry, Representative McKenzie, I didn't see your hand there. You're recognized.
Thank you, Madam Chair. And it's just a quick question on these free, not just, I've had a couple of my constituents call me on it. What's the process for either individuals to get the safes or to become like a nonprofit? I mean, the gun locks or a nonprofit that may want to have a drive where, you know, they bring people to a common event to pick up the gun locks. Are you familiar with when and what the process is going to be for that?
Chairman White.
From what I understand, that will be done within the policy once this bill is passed. But it says here that the department will prominently display on the department's website instructions on requesting free or firearm locks.
Right. Further questions? Seeing none, we're voting on House Bill 7012. All in favor, please signify by saying aye. Aye. Any opposed? Ayes have it. House Bill 7012 goes to calendar and rules. Thank you, Chairman White.
Thank you.
You have the next item on our agenda as well, House Bill 7033. Do I have a motion? Motion. I have a motion and a second. Chairman White, you're recognized.
Thank you, Chair Lady and committee. Received this one from our speaker. What this deals is accountability for bailable offenses. Basically, this puts into place when a defendant has been arrested and held to answer for a bailable offense, that the clerk of the court that admits the defendant to bail shall within 48 hours, 2 days of the defendant being admitted to the or receiving bail, publish on the clerk's website a report listing the following information for each defendant. Those three items are the offense to which the defendant received the bail, the amount and the conditions of the defendant's bail, and the name of the magistrate, judge, or other judicial official or clerk admitting the bail. It's just letting the public know what kind of bail the person received and what the offense was for accountability purposes. And with that, Madam Chairman.
You've heard the sponsor's explanation. I see no hands. So without objection, we're voting on House Bill 7033. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. The bill moves to calendar and rules. Thank you, Chairman White. Next on our agenda is House Bill 7032 by Chairman Williams. Chairman Williams, at your desk.
Thank you, Chair Lady and members.
Do I have a motion?
Motion.
I have a motion and a second. Thank you, Chairman Williams.
Thank you, Chair Lady members. House Bill 7032 as amended would require healthcare parity as it relates to mental health reimbursement and the reimbursement of costs. As we discussed in subcommittee, I'll be brief. Currently, there is a severe shortage in mental health providers, and that is in part by the decreased amount of reimbursement for mental health services, both inpatient and outpatient across the state. This bill seeks to increase that those reimbursement rates to the same federally mandated mental health and substance abuse, addiction and substance abuse treatments, which currently take place in our state. With that, Chair Lady members, I would take any questions you might have.
Any questions? Seeing none, we're voting on House Bill 7032. All in favor, please signify by saying aye. Aye. Any opposed? Ayes have it. House Bill 7032 moves to calendar and rules. Next on our agenda is item number 11, House Bill 7026 by Chairman Zachary. We have a motion and a second. Chairman Zachary, you're recognized.
If you're judicially committed to a mental institution or adjudicated mentally defective, you cannot possess a weapon. Right now, there is a gap in our system where if you're 16 or over and you have been adjudicated mentally defective or in a mental institution, that information is not flowing through to TICS. The Tennessee Instant Check System, this allows that information and now pushes that information forward to ensure that TICS is updated. That'll be glad to answer any questions.
Sorry. Questions for the sponsor? The question has been called on the bill. Without objection, we're voting on House Bill 7026. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House bill moves to calendar and rules.
Thank you, Madam Chair and Committee.
Next on our agenda is item number 12, House Bill 7035 by Representative Gillespie. Representative Gillespie, you have a motion and a second. You are recognized.
Thank you, Madam Chair. And I have a technical, an amendment with just a technical drafting error.
All right, and I believe the drafting code I have is 009636. Is that correct?
Yes, ma'am.
All right, we will, without objection, to have a motion. We have a motion and a second. We're voting on the technical amendment 009636. All in favor, please signify by saying aye. Any opposed? The ayes have it. The amendment is attached. So Representative Gillespie, please explain your bill as amended.
Thank you, Madam Chair. This bill is brought to us by Speaker Sexton and myself. What we're doing here is trying to fill the void of mental health professionals in the state by offering some incentives with a student loan repayment program grant that would offer repayments in the form of a grant to people entering the fields of psychiatry, psychology, and mental health counseling throughout the state. That pretty much sums it up, but I'd be more than willing to go into as much detail as y'all want. And with that, I welcome your questions.
All right, Representative Freeman, you're recognized.
Thank you, Madam Chair, and to my old seatmate and neighbor and everything. This comes from a place of love, but you and I have discussed this actually, and I think we're missing the mark here. The majority of people's first access for mental health is within a social worker, and not including them in this grant process, I think is really a miss. And I'm bringing it up now because when we come back next year, I plan on, if this passes, I plan on bringing a bill to advance it. But I just want to make sure everybody understands that the majority of times when you go see a therapist, it's a family counselor or a social worker. It's not a psychologist or a psychiatrist. And we need to make sure that if we really want to expand access to mental health, that we're getting the help where it's, or putting the money where it's going to do the most help. So anyway, I just want to put that on the record right now. Thank you.
Thank you.
I see no further questions. So without objection, I'm sorry, Representative Sparks.
I just want to tell you, thank you for this legislation. Members, I was recently at a Trust Point meeting about mental health, and they were saying only 3% of nurses are even going into mental health and helping these behavioral areas. It is really a tsunami that's going to hit us here in the next few years with the lack of care. Y'all have heard me share the letter of the late Dr. Linda Gilbert, school superintendent. We put an opioid mental health roundtable in my community together, well attended with judges, representatives there. She wrote me the letter, and sadly she passed away right after she wrote the letter. But she said the behaviors of these 6 to 9-year-olds are like something we've never seen before. They're disorderly, disruptive. She said we've got to concentrate on the whole child, and she said we need more counselors, and she said we need more social workers. And this lady had a doctorate in education, probably knew more about education than any member in the Tennessee General Assembly, I'll dare say. But I appreciate your legislation. I appreciate the speaker's indulgence in looking at this and being creative. Thank you.
Thank you. Without any objection, we are voting on House Bill 7035. All in favor, please signify by saying aye. Any opposed? If you'd
Thank
like
you.
to be a no, recorded as a no, then please let the clerk know. But the ayes do have it, and the House Bill 7035 does move to calendar and rules. The next and last item on our agenda is House Bill 7038 by Representative Gant.
Thank you, Madam.
Gant, you're recognized.
Thank you, Madam Chair,
We have a
Committee.
motion. We have a motion and a second. Thank you.
This directs the Department of Education to establish and administer a school safety alert grant program. The purpose of the program is to provide grants to LEAs and public alert, and public charter schools to establish the school safety alert systems in public schools. The alert systems funded through this grant program must be approved by the Department of Education and in consultation with the Department of Safety. And This also establishes that a first alert system can be included as an approved expenditure under the current grant program. And with that, Madam Chair, I'll answer any questions.
The question has been called. Seeing no objection, we're voting on House Bill 7038. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 7038 moves on to calendar and rules. That does complete our calendar for today. I go to Chairman Zachary.
Thank you, Madam Chair. Members' calendar and rules will start at 3:20.
We have no further business. We stand adjourned, subject to the call of the chair.